When a system gets something wrong once, how long does it take that same system to correct itself? The answer, most of the time, is longer than anyone would guess. Longer than a trial, longer than a sentence, sometimes longer than the years that sentence takes from you. This is what that distance actually looks like, level by level, from the first mistake to the moment it finally gets fixed. Level 1. You are 29 years old, and a convenience store 2 blocks from your apartment gets robbed at 9 in the evening. You were not there. You were home, alone, which sounds like an alibi until you realize alone means nobody can confirm it. A witness, rattled and doing her best under bad lighting, describes a man roughly your height, your build, your general coloring. A detective named Carl Nesbitt is working 4 other open cases that month, each one competing for the same handful of hours in his week, and your name comes up because you were arrested for a minor charge 2 years earlier, 3 blocks from that same store. It is not evidence. It is a starting point, and starting points under enough pressure to close a file before the month's numbers get reviewed have a way of becoming conclusions long before anyone intends them to. Level 2. You are shown to the witness in a lineup that is not blind, meaning the officer administering it already knows which position you are standing in and knows which name the department is hoping she confirms. This detail will matter enormously in 11 years and means nothing to anyone in the room tonight. She hesitates, studying 5 faces that all resemble each other more than any of them resemble her memory of the man from the counter. Then she picks you. Hesitation in the moment reads as caution, as a witness taking the decision seriously. In hindsight, hesitation is often the sound of a memory being quietly talked into, a certainty it never actually had. Level 3. You cannot afford a lawyer, so one is assigned to you, a public defender named Angela Vance, carrying 63 other cases that same season, each one requiring motions, meetings, and preparation that there are simply not enough hours in a week to give all of them equally. She meets with you for 20 minutes before your arraignment and 11 minutes before your trial actually begins, reviewing a file she has not had time to read closely, asking questions she does not have time to follow up on. She is not careless. She is simply outnumbered by a caseload, the system built to be outnumbered, and the difference between those two things rarely matters to the person sitting where you are sitting, waiting for someone to notice what she has not had time to notice. Level 4. The trial lasts 2 days. The prosecution's entire case rests on one witness and one detective's testimony about your prior arrest, introduced not as proof but as atmosphere, the kind of detail a jury is technically instructed to set aside and almost never actually does once it has been said aloud in a quiet room. There is no physical evidence connecting you to the scene, no fingerprint, no camera footage clear enough to confirm a face, nothing beyond a description given under bad lighting, and a lineup built to encourage the answer it received. None of that turns out to matter. The jury deliberates for 4 hours and returns with guilty. The judge, working from sentencing guidelines that leave him almost no discretion to weigh how thin the case actually was, gives you 18 years and reads the number the way a man reads a number he has read many times before. Level 5. You arrive at a state facility still saying the sentence out loud to yourself in the evenings because it does not yet sound like something that happened to you. It sounds like something that happened to a stranger wearing your name and answering to your number. The first year, you file every request the system allows. Transcripts, records. A retrial motion your public defender, still carrying her 63 cases, files on your behalf without much hope in either of your voices by that point. It is denied in 9 minutes, roughly the length of time it takes a different judge to read a 2-page summary written by a clerk who was never present in that courtroom and has no reason to look past what the paperwork already says. Level 6. Years accumulate the way they do in a place built to make years feel identical to each other. 1 count and 1 meal schedule, folding into the next until the calendar stops meaning much of anything. You write letters. to a newspaper that never replies, to a legal aid clinic that replies once, briefly, explaining it cannot take new cases that quarter, to an organization built specifically around cases like yours, 400 miles away, that receives roughly 2,000 letters like yours a year and has the resources to seriously investigate perhaps 30 of them. Your letter sits in that stack, one folder among thousands, for 11 months before anyone with the time to read it closely actually does. Level 7. A law student named Priya Anand, working an unpaid summer position at that clinic, mostly filing and sorting, is the one who eventually reads it. What catches her is not a claim of innocence. Everyone in that stack claims innocence. That is simply the baseline noise of the pile. It is one specific detail buried on page 4. The lineup was not administered blind. She flags it for a supervising attorney who has seen 100 letters like yours go nowhere. And for the first time in 7 years, someone with the actual standing to do something opens your file with genuine curiosity instead of genuine exhaustion. Level 8. The clinic petitions for access to evidence that was logged and stored after your trial and, by policy, rather than by anyone's individual decision to preserve it, never destroyed. A blood sample from the scene, tested at the time with methods that could only exclude a match and never confirm one, sits untouched in a property room for 9 years, waiting for a technology that did not exist yet at your trial to finally catch up to it. It takes the clinic 14 months of motions, hearings, and a prosecutor's office reluctant to reopen a case it already closed, just to secure the legal right to retest a sample that has been sitting 11 feet from a filing cabinet the entire time. 14 months to ask a question that a laboratory will ultimately answer in 11 days. Level 9. The results come back, and they do not match you. A separate database search run on the sample flags a different name entirely, a man already serving time in another state for an unrelated offense with a pattern of prior conduct that fits your case with uncomfortable precision. Your attorney requests an emergency hearing. It is scheduled for 6 weeks later, because emergency inside this system is a relative word bound by a court calendar that has never once treated it as one. Level 10. You sit in the same kind of courtroom you sat in 11 years earlier, at the same defense table, though everyone else in the room has changed. The face is different, the case number the only thing that stayed constant. The judge reviews the new evidence for 11 minutes before making a decision that took the system 11 years to arrive at. Conviction vacated. You are told you are free to go, and for a moment you do not move, because the sentence you have been living inside has become the only shape you know how to occupy. And freedom after 11 years does not arrive as relief. It arrives as a size you have to grow back into slowly, one ordinary decision at a time. You walk out with a bag containing what you had when you walked in, clothes that no longer fit the way they used to, and a discharge document that says exonerated in a font no larger than the one that once said guilty. In your state, that document comes with no automatic compensation. You will spend the next 2 years fighting a different system entirely, a civil one this time, simply to be paid for time that system now agrees, in writing, it should never have taken from you in the first place. Here is the actual answer to the question this video opened with. The system took 1 afternoon to arrest you. It took 2 days to convict you. It took 11 years, 1 overlooked letter, 1 unpaid law student, and 1 blood sample nobody thought to retest until the technology finally caught up. To admit it was wrong. Getting something wrong is fast. A witness under bad lighting, a detective under deadline pressure, a jury given 2 days, and 1 thin case. Fixing it is slow, because fixing it requires someone with almost no institutional incentive to look twice, choosing to look twice anyway. That is the actual distance this video has been describing the whole time, not the distance between innocent and guilty. The distance between a mistake and the moment somebody finally has the standing, the evidence, and the will to correct it. If this changed how you think about what happens after a wrong verdict, subscribe to the 10 levels. New levels every week.